Welcome to the FCC. My name is Tara Joseph. I'm a journalist with Reuters and vice president of the club this year. We're delighted to have a packed house today. Just a couple of quick housekeeping notes before we get going. Please do remember to switch your phones back on when you leave the club, as we're recording today's session. Everybody in Hong Kong knows that the judiciary is the bedrock of what makes Hong Kong such a special place. The common law in Hong Kong is guaranteed by the Basic Law until June 30, 2047. Now that may feel like a long time away. It's 32 years from now to be exact. That is 32 years has already passed, however, since the Basic Law has been drafted. So how long is it really? And what does it mean for Hong Kong when we hit that 2047 date? Our guest speaker today definitely has an indication of whether the judiciary in particular is preparing well for 2047. The Honorable Henry Litton has recently retired as a permanent judge of the Court of Final Appeal after a very distinguished career. He has been the longest serving chairman of the bar in Hong Kong. He was the youngest of his generation locally to be named Queen's Counsel. And importantly, he is also an enormously accomplished tennis player and sailor, and known throughout Hong Kong for that as well. We will hear from Henry Litton, and we hope to have time for Q&A at the end. It's my honor to introduce the Honorable Henry Litton.
Thank you, Tara. 32 years ago, two great sovereign powers, Great Britain and China, were locked in discussion over the future of Hong Kong amidst general doom and gloom. The bottom had fallen out of the stock market, real estate values were plummeting, and professionals were leaving the colony. Eventually, the Sino-British Joint Declaration was signed in Beijing in December 1983, with China undertaking to preserve Hong Kong's governing system and lifestyle for 50 years from the 1st of July 1997. I was among those invited to witness the signing ceremony in Beijing. It was a huge landmark in the history of Hong Kong, 32 years ago. Now look forward 32 years, and we will be a few months past the 30th of June, 2047. So today, in a sense, is a pivotal time for Hong Kong with its future in the balance. The common law. Key to the entire scheme for Hong Kong's future has been the preservation of the common law, the governing system since 1844. The common law represents basic legal concepts and values which are universally recognized. English is the common language of the common law. This gives it great strength. It explains to a large extent why Hong Kong evolved so quickly from a small trading post to a major financial center of the world. The towering office blocks of Central were built not only on the bedrock of the island, but also set upon solid global foundation of legal principles. Soon, maybe very soon, discussions will need to take place again over the future of Hong Kong. Without a timely decision regarding post-2047, international and local business confidence will once again rapidly drain out of Hong Kong. Do not forget this. Whilst Article 120 of the Basic Law recognizes land leases granted by the British Crown before the 30th of June 1997, these are nevertheless wasting assets. They may increase in value now, but they have to be amortized to zero by the 30th of June 2047 under internationally recognized accounting rules. This massively affects the balance sheets of major companies whose shares are quoted in London and New York as well as in Hong Kong. Of course, the central government could always extend government leases by, say, payment of a premium and fresh annual rents. But what about the Conveyancing and Property Ordinance, the Land Registration Ordinance, and all the common law principles which underpin land value? And remember this, it was precisely the fast expiring New Territories Crown leases which propelled the Prime Minister, Mrs. Thatcher, to Beijing in early 1983, and the bruising encounter with Chairman Deng Xiaoping, which caused her nearly to fall down the steps of the Great Hall of the People. What has Hong Kong got to offer? When such discussions about the future of Hong Kong once again take place, there will be some who will argue that English should cease to be an official language. And if at that time the common law system is seen to be flabby, slow, costly, pedantic, obscure, the question will be asked, how can such a system be put forward as a model for a global financial and business center? What is more, Hong Kong will then be on its own. There will not be another sovereign power alongside contending for the continuation of our governing system and lifestyle, as Britain did in 1983. What has Hong Kong got to offer when the time comes? We don't have gas, oil, minerals, coal. We have no industry to speak of. The verdant rice fields of Sha Tin, Tai Po, Yuen Long are long gone. Our seas are cleared of fish. We import water from the East River and electricity from Daya Bay. When the question is asked, what has Hong Kong got to offer? The first answer very often is rule of law. The rule of law that underpins our financial system, facilitates trade, regulates commerce, guarantees land value. Rule of law. These are big words. And they are empty words without the discipline of law, the clear and precise framework of practice and procedure within which justice according to law can be dispensed effectively. The common language of the common law, as practiced all over the world, is English. Yet some 80% of our population, governed by the common law, do not speak English. So if there is one thing that stands out in the discipline of law in Hong Kong, it must be this, that judgments handed down by the courts should be brief, direct, written in simple English, so that they can, if necessary, be translated into Chinese. Obscurity spells injustice. We have recently seen court cases involving public order. These have taken up much court time and resources. One court case involving a procession of about 100 people from Chater Gardens in Central to the police headquarters in Wan Chai, along the busy Queensway on a working morning, started in the Magistrates' Court and ended up in the Court of Final Appeal. At the core of the case was a practical issue, how to accommodate the rights of people to demonstrate given the road conditions of that day. On appeal, the question was no longer the practical problem of congested road space in central Hong Kong on a busy working day. The argument had shifted onto philosophical plane. The debate was about the competing values of free speech, the right of peaceful assembly, of street demonstration, as against the general requirements of public order. Examples of dubious relevance from overseas were dragged into the debate. The judgments of the Court of Final Appeal came to 218 paragraphs and cited cases, wait for it, from all over the world, including Ghana, Lesotho, Tanzania, and South Africa. What on earth have those cases got to do with problems on the streets of Hong Kong? And how could a judgment like that possibly be translated into Chinese? How would the system work under stress? Now, that was just one street demonstration on one day in one place. How would the courts now cope with a situation such as those we have seen in the past involving tens of thousands of people? In the early 1960s, there were long queues of people jostling for space at standpipes all over Hong Kong and Kowloon and the New Territories, waiting to fill their buckets when water rationing was cut down to 4 hours every 4 days. Inevitably, fights broke out at the standpipes. People were arrested, brought to court, dealt with humanely, speedily. Then in 1967, the Cultural Revolution spilled over the border. There were riots all over the colony. Thousands of rioters were arrested. Somehow the court system coped. That was because of the discipline of law. In those days, the protection of fundamental freedoms was provided by the common law. Since that time, 2 additional weapons have been added to the armory for the defense of individual freedom. One, the Hong Kong Bill of Rights, enacted in 1991, which brought in the concepts of the ICCPR, International Covenant on Civil and Political Rights, and as part of the domestic law of Hong Kong. And 2, the Basic Law itself, which came into effect in 1997. The enactment of the Hong Kong Bill of Rights was greeted with whoops of delight by some lawyers. They saw it as the new game in town. Let me give you an example. The case of Attorney General against Hui Kin Hong in 1995. On a charge of corruption under Section 10(1)A of the Prevention of Bribery Ordinance made against a Crown servant, a district judge was persuaded by counsel to strike down the section, declaring it inconsistent with the presumption of innocence in the Bill of Rights. This was, as everyone knows, a key provision in the fight against corruption. To establish the charge, the prosecution must prove beyond a reasonable doubt that the defendant had maintained a standard of living incommensurate with his official emoluments. The burden then shifts to the defendant to show how that has come about. The statute says that if he fails by a substantial margin to do that, he is guilty of a corruption offense. Some have described Section 10 as draconian, and in a sense it is. But how a person is able to maintain his own standard of living is something peculiarly within his own knowledge. And corruption, by its very nature, occurs in secret. Whether Section 10 is consistent with the presumption of innocence as provided for in the Bill of Rights depends ultimately on the circumstances of Hong Kong. There is no universal blueprint for the presumption of innocence that can be simply applied locally. I was part of the court in Hui Kin Hong, presided over by the Chief Justice Sir T.L. Yang. We could see the specter of rampant corruption creeping back into the system if we did not allow the Attorney General's appeal. The court viewed the situation locally. We did not scour the world for an answer. Mr. Justice Bokhari gave the judgment of the court, barely 8 pages. The district judge's decision was reversed, and Section 10(1)A was restored to the statute book. That was back in 1995. No trumpets, no fanfare, just the ordinary work of an appellate court, in tune, if you like, with the tempo of the age. Since that time, a whole raft of cases, directives, authorities, statements of the European Court of Human Rights, writings of learned authors have been imported into Hong Kong, and there is not a case concerning human rights in Hong Kong in which counsel does not cite such material. One wonders how a case like Hui Kin Hong would be presented by counsel and decided by the courts today. Over 20 years ago, the Privy Council in London sounded a note of warning to the Hong Kong courts in a case called Attorney General against Lee Kwong Cut, quotes, and I quote from the brief passage. While the Hong Kong judiciary should be zealous in upholding an individual's rights under the Hong Kong Bill of Rights, it is necessary to ensure that disputes as to the effect of the bill are not allowed to get out of hand. The issues involving the Hong Kong Bill should be approached with realism and good sense and kept in proportion. If this is not done, the bill will become a source of injustice rather than justice and will be debased in the eyes of the public. Judicial review and the discipline of law. If there's one area of the law where discipline is required, it would be in applications for judicial review. To ensure that government departments, public authorities, etc., are not vexed with hopeless complaints, the rules of court have built in a two-step process. First, the applicant must apply to a High Court judge for leave. He lodges his papers, and then it is the responsibility of the judge to see if he has reasonably arguable case for one of the orders set out in Section 21K of the High Court Ordinance. For instance, an order to quash a decision made by a minister or departmental head which adversely affects the interests of the applicant, or for an order of prohibition to stop the minister or departmental head from acting unlawfully, again in a matter in which the applicant has an interest. As you can see, these are grave and weighty matters and should not be lightly undertaken. A quashing order or an order of prohibition could have very wide implications affecting the whole community and not simply the applicant himself or herself. If the applicant has no case, his application is summarily dismissed by the judge, it will receive no hearing in court. That is why in the leave application, the public authority concerned is described as proposed respondent or putative respondent. It is only when the judge concludes there is an arguable case for granting relief that he or she gives leave for the applicant to take out an originating summons, serves it on the affected parties. That is when the process itself begins. Judicial review is not available for challenges to government policy. That is a fundamental rule in the separation of powers. The court is concerned with law, not policy, for obvious reasons. The courtroom is the place for the vindication of legal rights, redress for wrongs done. It is not a debating hall or a classroom. It is only when a public authority has acted unlawfully or gone outside its lawful powers or abused its powers given by a statute, etc., etc., that the court can intervene. Give you the example of the case of television broadcasts against the Communication Authority and Chief Executive and Counsel. In early 2013, TVB applied for leave to start proceedings against the Communication Authority, formerly known as the Broadcasting Authority, and the Chief Executive and Counsel. These were the proposed respondents, described as such in the papers lodged in support of the application. The papers went before the judge in charge of the constitutional and administrative law list. Instead of the judge dealing with the application ex parte, that is, with the applicant alone before the judge, as the rules prescribe, notice was given to the proposed respondents, and a date was fixed for a hearing. So two teams of lawyers appeared before the judge in court to argue as to whether there was anything arguable. Does the exercise not stultify itself from the very start? In a so-called judgment delivered 6 weeks later, the judge concluded that there was nothing remotely arguable in the application, which he dismissed. It took him 45 paragraphs to do so. It should not have taken more than a single paragraph. After all, 0 equals 0. judgment, in quotation marks. The judge called his 13-page document a judgment. That was a misnomer. A judgment follows a trial and resolves issues between parties. Here the judge determined there were no issues, full stop. Was this a mere slip by the judge, or was he confused about his own function? I suppose you could say that the so-called judgment served one purpose. It exposed for all to see the inanity of counsel's arguments in the case. The background to TVB's application for leave to bring proceedings for judicial review goes back about 6 years. There were only 2 free-to-air TV stations in Hong Kong, TVB and ATV. The government had received applications from 3 other companies for the grant of free-to-air licenses, which, if acceded to, would have posed competition to the 2 existing stations. The Broadcasting Authority carried out public consultations, engaged professional consultants to conduct a competition analysis. Based on the results of the consultations and the consultants' report, the authorities submitted recommendations to the Chief Executive and Council, suggesting that the applications by the 3 companies should be approved in principle. This was in July 2011. 2 years later, TVB took out the present application. It is not clear from the judgment what precise order TVB sought. The most likely seems to be an order of prohibiting the Chief Executive and Council from acting on the authority's recommendation. TVB's complaints, as summarized by the judge, were these. 1, it had only been given redacted copies of the consultant's report. 2, there were errors in the report, particularly regarding revenue from TV advertising. And 3, TVB was a major stakeholder in the free-to-air TV market and had not been properly consulted. The judgment identified no right or interest of the applicant which had been affected by the action of the authorities. The matters complained of could not remotely have caused a court to intervene and give relief. The only thing about the whole exercise is this. The judge in his judgment quoted, the odd thing about the whole exercise is this. The judge in his judgment quoted with emphasis an English judge to this effect, quotes, "Judicial review generally is concerned with actions or other event which have or will have substantial legal consequences, for example, by conferring new legal rights or powers, or by restricting the existing legal rights or interests," unquote. From the very beginning, it must have been obvious that there was no decision or action affecting TVB's legal rights which could remotely come within the scope of judicial review. Why then did the judge not simply say so and dismiss the application summarily in 1 paragraph, since it plainly was nonsensical? Now note this. Had there been anything arguable in TVB's application, and if the possibility had existed of some form of relief being given by the court, for example, prohibiting the Chief Executive and Council from acting on the Broadcasting Authority's recommendation, then obviously the 3 companies concerned would have been interested parties, entitled to be heard. But they were not before the court. So you can say that the result was preordained from the very start, and the entire exercise was one in total futility. At the conclusion of his judgment, paragraph 46, the judge said, quote, "It remains for me to thank counsel for the helpful assistance in this matter." Was this just ritualistic politeness, or did the judge really mean it? This becomes profoundly troubling. Was the judge really saying that counsel's assistance might have turned the table round, that he might really have given TVB leave to start proceedings for judicial review? If he had done so, what then? Under the rules, TVB would lodge what is called Form 86A, take out its originating summons, serve the papers on the three companies. Well, would the judge then go through the whole exercise again, this time with the three companies as parties before him, with obviously the same result, since the three companies before the judge arguing the case against TVB could hardly improve TVB's chance of success. In the two recent cases in the High Court, which you probably have seen reported in the newspapers, concerning the method for selecting the chief executive in 2017, exactly the same procedure in the TVB case was adopted. As most of us are aware, the government had, back in October 2013, set up a task force headed by the Chief Secretary, the Secretary for Justice, the Secretary for Constitutional and Mainland Affairs, to conduct public consultations regarding the method for selecting the chief executive in 2017 and for forming the legislature in 2016. Following this, on 15th July last year, the chief executive reported to the Standing Committee of the National People's Congress that there was need to amend the method for selecting the chief executive in 2017. This then led to the Standing Committee's famous decision of Samyatpad, the 31st of August 2014, stating that the selection of the chief executive might be implemented by the method of universal suffrage, setting out the framework under which this might be done. Following the Standing Committee's decision, the task force published a consultation document on the 7th of January this year, initiating a 2-month period of public consultations. Then, after the consultations, on the 22nd of April this year, the task force issued its report and put forward proposals on the method for selecting the chief executive. It is these three acts of the executive arm of government which form the focus of the two applications for judicial review. One, the chief executive's report of the 15th of July last year to the Standing Committee of the NPC. Two, the consultation document published by the task force on 7th of January this year. And three, the task force's report and proposals of the 22nd of April concerning the method for selecting the chief executive. Now, these three acts, reporting, consulting, putting forward proposals, each of these three acts is an act of an orderly government and could not by any stretch of the imagination be categorized as unlawful, ultra vires, abuse of power, or anything else that could remotely have brought these acts within the purview of judicial review. Instead of summarily dismissing the applications ex parte, the judge once again went through the motion as he did in the TVB case. A date was fixed for the hearing, notice was given to the putative respondents, teams of lawyers appeared before the judge in open court. The case, first of all, concerning the chief executive's report, which is the case of Kwok Chuk Kin, against the chief executive and, wait for it, the government of the Hong Kong SAR. Now, the notion that the entire government of the Hong Kong SAR should be subject to review is totally absurd and is symptomatic of how far the system has been abused in recent times. The government of the Hong Kong SAR would obviously include the chief executive himself, all his ministers, all the secretaries, all the directors, all the deputies, maybe the administrative officers, etc., maybe even the executive officers. Would there be space in court as they all crowded in as putative respondents? And who would run the government as they sit all day in court? You would not need terrorism to bring the government down. One look at Mr. Kwok's ex parte application should have convinced the judge that the proposed relief against the chief executive was equally absurd. How the making of a report by the head of government to the central government could be categorized as unlawful or abuse of power or ultra vires or anything else of that kind is just beyond bizarre. Mr. Kwok's application was simply grandstanding, a misuse of the court process. Instead of having it summarily dismissed, as the rules of court required, the judge conducted a hearing in April this year. 2 months later, he gave what he called a judgment, dismissing inevitably the application. The judgment, so-called, makes for bizarre reading. Since the conclusion was that there was nothing to argue and that leave should be refused, how is it consistent with the outcome that there should be 30-odd paragraphs of discussion? It seems from paragraph 29 of the judgment, for example, that counsel sought from the judge general guidance on the way public consultations should be conducted. It shows how far proper discipline has been leached out of this branch of the law. What possible guidance can judges give to the executive arm of government as to how the public should be consulted? And what on earth has this got to do with the remedy of certiorari, the term used in the High Court ordinance for a quashing order? Why should the judge pay heed to such nonsense and solemnly set it all out in his judgment? Grandstanding of this kind should be given no oxygen. The other two acts concerning the task force, the Chief Secretary, the Secretary for Justice and the Secretary for Constitutional and Mainland Affairs, was a case brought by a Madam Leung Lai Kwok, Yvonne. And you may remember, as I mentioned earlier, the two acts of government were, one, publishing the consultation document on the 7th of January this year, and two, making a report and proposal on the 22nd of April this year. And that those two acts became the focus of Madam Leung's application for judicial review in May this year. Once again, this was an abuse of process. Once again, instead of summarily dismissing the application, the judge conducted a hearing attended by teams of lawyers. Once again, there were no grounds whatsoever for the matter to proceed to a hearing. The application for leave was dismissed inevitably in a judgment of over 60 paragraphs. Piling words onto a foundation of sand adds nothing to the jurisprudence of Hong Kong. It debases the system and makes mockery of the law. In respect of Madam Leung's case, I would make this additional point. The three principal secretaries constituting the task force were made putative respondents, number 1, number 2, number 3. But the chief executive himself was brought in as a fourth putative respondent. Now you go through the 60-odd paragraphs of the judgment with a fine-tooth comb, with a microscope if you like, and you will not find one word from counsel as to how the chief executive could have come within the scope of relief by way of judicial review. The judge made no comment on this point, but it should not be ignored. This was simply grandstanding, inappropriate posturing, and should be roundly condemned. As if Madame Leung was hoping one day to put into her CV the fact that she had sued the Hong Kong chief executive. The cost to the community. As an example of how the process of judicial review can be costly to the community, take the Hong Kong-Zhuhai-Macau bridge case. The Hong Kong segment of the bridge involved three major engineering engineering projects. This meant that the Director of Environmental Protection had to be satisfied with the Environmental Impact Assessment Report submitted by the proponent of the scheme, the Highways Department, before she could issue the work
Start
permit.
with one quick question, if I can.
The process of environmental
is
protection,
what-
impact assessment, was elaborate and took a considerable time. It involved periods of public consultations. The judge of first instance had got it all wrong. He had made a mistake. By then it was far too late to arrest the consequences of the mistake. At that time, the estimate of the Institute of Environmental Impact Assessment was that the project was delayed by 2 years and at a cost of US dollars 1 billion. We do not have the exact figures. What we do know is that the government has recently asked the Finance Committee for an extra Hong Kong dollars 5.46 billion with 1.6 billion in reserve. The completion date has been delayed 1 year. The judgments in the bridge case are massive. 189 paragraphs at first instance, 125 paragraphs on appeal. I do not suppose any journalist in this room today has read the judgments. One thing is sure, there is no way those judgments could be translated into Chinese to make sense. Is that why the bridge case, which caused loss to the taxpayers in the billions of dollars, evoked barely a murmur of protest from the community? The judgments are so obscure that no one can understand them. And yet, if there's one thing which symbolizes the relationship between Hong Kong and the mainland, it would be that bridge. The delay at the Hong Kong end must have had impact on the project as a whole. How was this explained to the mainland authorities concerned with the construction of the bridge? I come to my conclusion. The legal system in many instances is wrapped in obscurity, clothed in mumbo-jumbo, suffocating under citations and drowning in irrelevance. The harsh question must be asked, is the Hong Kong judiciary sleepwalking towards 2047, wandering in a dream world of its own, a world of authorities, legal texts, precedents, black letter law, as if those were the entire substance and reality that exists? Is it detached from the world of people whose only language is Chinese? As General Colin Powell, Secretary of State in the first George W. Bush administration, said, quotes, "Great leaders are great simplifiers. They make statements which everyone can understand." As 2047 closes in, what Hong Kong needs to present to the world is a robust, vigorous legal system, one that is clear-cut, expressed in language easily understood. The Chief Justice has recently set up a Judicial Institute to help judges. I'm sure he is aware of some of the problems ventilated in this talk. My hope is that resources will be urgently deployed to arrest what I see is a pernicious trend, a trend away from simplicity and clarity in the law towards complexity and opaqueness. Thank you. You see the same trend actually in other overseas common law jurisdictions as well. And some of the judgments coming out of the courts in Australia, for example, with which I'm now reasonably familiar, again dwells upon a philosophical plane rather than dealing with hardcore reality of the case itself. As if somehow the judges feel that they need to make of the law a fluid thing so that there is room for development. That, at any rate, is how the matter was explained to me when I challenge this approach. That may be a good thing if one has a regime that will last 1,000 years. But in the circumstances of Hong Kong, my suggestion is that we don't have the luxury of such treatment, and that the only way in which one can satisfy authorities that the common law is worth keeping is to make it simple and direct.
As somebody who covered court cases as a reporter for 18 years and sat in Mr. Justice Litton's court on many occasions, I certainly support a call for brevity and clarity in court judgments. But I wonder the question about why judges entertain and go to so much trouble with certain judicial reviews. Could it be that with these sensitive political issues which the judiciary are drawn into?
Yes, I've heard that being put forward before, several times in fact, that the judge ought to give the appearance of listening to complaints, however outrageous, however irrelevant, because they are entitled to what is called their day in court. I completely suggest that that is completely wrong. The task of the judge is not to indulge either the parties or their legal advisors or their legal team. The sole role of the judge is to resolve the issues of the parties themselves with efficiency and with brevity. And in a civil case, you will very seldom satisfy both parties, because more often than not, you just give judgment for one side, which means the other side loses. And does it matter very much to the losing side whether they lost through a mountain of words or through clarity of reasoning? They will still feel aggrieved either way. And adding the mountain of words, I don't think would sort of mollify their sense of grievance.
Rule of law is important, and I think it is under threat in Hong Kong for the very reasons that you outlined. What practical steps would you take to ensure the rule of law and to make sure that perhaps judges are better, the legal professionals improve?
I'm pessimistic. Bad habits die hard. Don't forget, about 7 years ago, the civil justice system underwent pretty profound reform with the CPR, the civil justice reforms. And new rules have been introduced to make the system more effective, more efficient, cut out satellite litigation as much as possible. That was 7 years ago. But as far as I can see, nothing much has changed with those reforms. Now, what I'm talking about is not just reforming the civil justice system. I'm talking about an entirely different approach to the responsibility of those who have the rule of law as their task. And short of, what, dare I use the word, a cultural revolution, what can be done?
The umbrella revolution, a lot of people who are combining law and economics have discovered to a very startling and disturbing conclusion that Hong Kong is one of the most entrenched cartels in the world. It comes up a lot.
I think you pile on a little bit too much responsibility on the judiciary. Don't forget there are three supposedly equal pillars that sustains the civil society: the executive, the legislative, and the judicial. And to perfect the sort of reforms that you have in mind, it really is the responsibility of the executive to put forward policies and for the legislative then to enact laws to deal with it. And it's not the responsibility of the judiciary to deal with these issues at all. And in fact, that is part of the problem that I've tried to outline, that the judiciary is asked to do too much and to intrude into an area which is not the area of responsibility for the judiciary. There are cases where government policy and the sort of reliefs that you can get from judicial review merges. Are you really attacking illegality, ultra vires, excessive power, abuse of power, or are you actually attacking the government policy itself that underlines or underlies the action that you're attacking? Now, very often these cases stray into the area of policy, and that is one of the problems, that the judges have not been robust enough, and to say, look, our responsibility is not in relation to policy. Now, of course, if you have a legislature which is dysfunctional and doesn't take full responsibility for proper governance of the community, then the sort of problems that you have just outlined emerge. It's not the responsibility of the judiciary to introduce antitrust laws. It's the responsibility of the executive and the legislative arm of government. I think my good friend CBO is teasing me, I think.
Well, the new ones which have come in, and those who will come in, will they have the same grit and guts as the old ones, the ones that have left?
Well, let me tell you this. When I was elevated to the Court of Appeal in 1992, I ceased to be an advocate in court, and I was then practicing advocacy on only two other colleagues, because if I could persuade them to my view, then we have a unanimous judgment in the Court of Appeal. My task became much more difficult in the Court of Final Appeal, because I then had to practice advocacy on four, and my effectiveness diminished in consequence.
My question for you is a simple one, however. Why do we have a Court of Final Appeal? Does it not just add another step, another layer to the process?
That's the way I think New Zealand went, isn't that right? I mean, if you have a wise, well-staffed Court of Appeal, which has unlimited jurisdiction, it will certainly be less laborious, less costly. And, well, I tend to agree with you. Why? I think the answer is that, yes, I mean, assuming that there were a whole bundle of talent in the Court of Final Appeal, why not deploy that talent at the now intermediate stage and strengthen the Court of Appeal and let that be the final appeal? Well, I think, why don't you put forward that proposal to those who can change the law?
Henry Litton, thank you very much for joining us today. I do hope that when you come back to Hong Kong frequently, you'll come to visit us at the FCC. We very much enjoy the intersection of wig and pen, and we have a small gift to present to you from the club. Thank you very much.